Asking for a Friend, the law you need to know, by butlerfirm.com.
Today we'll talk with my friend Kim Hoipkemier. I've known Kim for a long time. We were in law school together, and she's married to a good friend of mine. And Kim does estate planning work. So her firm is Georgia Estate Planning and Probate, and Kim is the planning part of that. So she writes wills, financial powers of attorney, medical directives, and all these other documents that have to do with death that we don't really want to think about but all really need. And Kim's very good at it. She did the will for me and my wife and a lot of my family members. So we're looking forward to talking with her today. Her practice area is a little bit different from mine, so I'll learn a lot and hope you will too. I'm Jeb Butler, and I'm here with Kim Hoipkemier, a friend of mine for a long time, married to another good friend of mine. And Kim helps us prepare for the unthinkable. Tell us what you do, Kim.
I do. I am an estate planning attorney, so I plan for the inevitable passing of us all, hopefully to handle it in a peaceful and organized fashion.
Tell us the name of your law firm.
Our firm is Georgia Estate Planning and Probate. So I am the planning side of our firm, and my partner Cassandra is the probate side.
I think you told me one time that most of what you deal with is death and taxes.
Yes,
Is that fair?
as awkward, funny, I don't know, as that sounds. Yeah, death and taxes is what I do. If you're asking me my elevator speech or my cocktail introduction, I do death and taxes, yes.
Okay. Well, we've all got to deal with them.
We've all got to deal with them.
Tell us who most of your clients are.
Okay.
Who do you help?
Good question. So I will start with everybody needs a will, right? The will is going to allocate your assets when you pass. Everybody needs powers of attorney, and everybody needs healthcare directives. So my typical clients are families.
Run that back slowly. A will, you said two other things.
A will disposes of your assets when you pass. It would also name a guardian if you have minor children, a financial power of attorney, and a healthcare directive. Now those latter two documents are what we call incapacity planning documents. So for our clients that are older, may have Alzheimer's or dementia, there's an incident, an accident that causes you to be unable to manage your affairs, you're going to want those two documents in place. Most of my clients, most people we see, are young families who are starting to think about getting these things organized.
Okay. Okay. So let's see. Let's pretend I want to put myself in some scenarios and see where you might come in. Because as you know, like our firm gets calls, and if we don't handle it, something like this, we refer them to you. Sometimes we'll get a call like, you know, my relative is in the hospital, they're not doing well, and we don't have anything planned. Can you help with
Sure,
this?
Absolutely, and we do get that call with some frequency. Unfortunately, we like to see folks when they're have all of their wits about them and can really make an estate plan, but there's certainly things that we can do even at that moment in time. First of all, we're going to look at the assets. How are the assets titled? Any beneficiary designations? We're going to look at the family. Is the client married? Are there minor children, adult children? Because all the answers to all of those questions really drive what we should do and what we can do at the last minute. Capacity is another issue if we've got folks in the hospital, but those are our drivers. We can certainly get documents done in a hurry if we need to, but really the phone call is there to make sure everything is organized, and we try our best to meet the client's wishes, right? If they're going to pass, we want their assets and their family to be taken care of.
You mentioned how assets are titled. What does that mean?
Big misconception, actually.
Okay.
Assets, so under Georgia law, if you have a jointly held account at Bank of America, your day-to-day checking account is jointly titled. By default, that account is a rights of survivorship account. So if just one account owner passes, it immediately becomes owned by the surviving account owner.
That sounds right.
Sure. As for a husband and wife, that's often correct. Okay. But what if mom is well into her 80s and she still has her capacity, but one of her adult children helps her pay bills, take care of things, so she adds her to the account. Mom dies, that account is the sole property of that one child. And so if there are some other siblings out there, they may be a little upset.
I see. So that's why you get the will. So instead of going to the one child, it goes to...
That's correct. Or we correct the titling at the bank. And we clarify if mom intends for that entire account to go to the adult child, or if mom intends for that account to be split among all of her children.
Yeah.
And that's the time that you can make that clarification, is when mom is there to say that. Because post-death, adult child said, well, I paid all the bills, I earned this. Siblings may say, no, her will says all things are 4 ways. Does that make sense?
Yeah, yeah.
So account titling is one, joint with rights of survivorship. Real estate is another. Most closing attorneys in Georgia now, when you buy a primary residence, are going to list your home jointly with rights of survivorship, meaning it passes to the survivor, which is, again, generally a good thing between husband and wives. And then beneficiary designated assets. That is the other big hole. Beneficiary designated assets.
What does that mean?
So if you think of most Americans, a retirement plan is part of their net worth. A 401k, an IRA, a 403b, right? A tax-deferred retirement plan, whether they've been saving for. It is a beneficiary designated asset. There is a document on file with whoever maintains that account as to where that account's going to pay when they pass away. And that document supersedes the will. So
it controls instead of
instead of as it pertains to that particular account.
Okay.
Okay, so if you've got $500,000 in a 401k and you name so-and-so on the beneficiary form, but your will says something different, the 401k form is going to control. So our job as the planner is to make sure the will coordinates with the beneficiary designation, coordinates with the asset titling, so that everybody gets what they think they're going to get and that mom and dad's wishes are achieved.
Right. So this makes sense. You did my will, me and my wife's will.
I sure did.
And then you had me go back and title things to where the beneficiary was like marital trust under Article 1 of the last will.
I sure did. I got very specific, didn't I?
Yes, it was in me. I copied it and pasted it.
Yes.
Lots of slides.
Spouses have a little bit better income tax advantages to inheriting tax-deferred retirement accounts. So spouses get their own special rules. Non-spouse beneficiaries have a little bit more restrictive rules. So we're very particular about non-spouse beneficiary designations. Layer on top of that a minor child. So if something happened to you and your wife, we have munchkins to receive the assets. They can't receive it directly, so your will creates a trust for their benefit, and that's where trust planning comes in.
I see. So a trust like holds the assets so they can be distributed to our kids.
That's right. And you're naming somebody to govern the trust.
Yeah. Okay. I thought about this and the scenario of like, I've got a relative, they're not doing well, we've done no planning, I need help. Like, maybe estate planning isn't my favorite thing to think about. Why not I just put this off till the last minute? Any problem with me doing that? She laughs. I think that was a no. I mean, yes, there was a problem. I don't know, you tell me.
Well, I'll tell you this.
Okay. You mentioned capacity.
I mentioned capacity, right? Capacity is a prerequisite to being able to draft an estate plan. You have to know.
What does capacity mean?
As it's defined for estate planning purposes is slightly different than as it's defined for the ability to enter into a contract. Okay? So you have to know yourself a bit about your assets, not super specifics. Know the natural, your natural heirs. So who's in your family? Who are the natural ones that are going to take if things were to happen? Can you form a rational thought? Do you understand more or less what you're doing? Okay? So if you are waiting to the last minute, you may or may not have all of your faculties, right? You may not have capacity to sign a document. You may not be able to clearly articulate your wishes, your family. Don't wait till the last minute.
Because if I did, like the relative or me might be out of my head, and then I can't sign a will. So
that's right.
It's too late.
Capacity. I mean, we're all living longer than we used to. But capacity is not a light switch. It's not like you have it one day and the next day you don't. It is a gray area where it comes in and out. And how am I the attorney to know? It's my job to analyze whether or not you have capacity or whether or not this ne'er-do-well is whispering in your ear when you are most at risk for being influenced in a manner that you're not necessarily intending to be. The other, maybe more practical thing is sometimes we have difficulty getting into hospitals. right? So if you were
Because
in the
COVID.
hospital, COVID locked us out.
Yeah.
We do a fair number of signings for folks that are in the hospital because that, like you said, is something when people think about dying.
Yeah.
The nurses are not real keen on serving as witnesses to these documents. So planning ahead is
That's right.
it's a gift to your family. I mean, that's the way you got to think about it.
How about this, Kim? Like I'm feeling cheap today. I think what I'm going to do is I'm just going to write down what I want to happen with my money on this legal pad, sign it, and put it in a safe. Then I don't need to hire you, right?
It is just as good as firewood.
Okay, tell me why.
Because Georgia law says that your will must be, it cannot be handwritten.
Okay.
It has to be signed by you in the presence of 2 independent witnesses.
Okay.
Okay? It should also be self-proved, which means you have a notary attest to the fact that the testator signed it in the presence of 2 witnesses. And that everybody was over the age of 14. And that you were of sound mind at the time you signed your will.
And if I did it on my own, I would have basically 0 chance of making all my accounts and the titling of assets coordinate
Correct.
with it.
Plus you're going to miss some pretty significant, Georgia is a relatively nice state to pass away in. Again, that goes back to death and taxes. Who says that?
Good.
I do.
It's great, Kim.
Georgia's a relatively nice state to pass away.
Okay.
Our probate process is generally considered to be one of the friendliest and simplest of the country.
Okay.
Is as long as you have the proper language in your will.
Okay. Another scenario, my wife and I are about to leave town. We're going down to Mexico. We're going to have us a good time. But I'm leaving the kids with my mom and I feel a little nervous. What happens if they need medical attention or something while I'm gone, or if the cartel takes me and Ann out while we're in, Tijuana? Can you help us plan for
Yes, we get this call frequently, as you can imagine. My husband, my spouse, my wife and I are traveling abroad or even domestically, leaving the kids behind. First of all, we want to make sure all your documents are in order in case the worst happens. But we also have a medical power of attorney or a consent for medical treatment for a minor child. So I filled one out, gave it to my parents. It's signed and notarized. You list the pediatrician, allergies, that sort of thing. But that way, if your child gets sick, then grandma and grandpa can take them to where they need to be seen and have the ability to get them help.
I honestly did not know that was the thing, but I should have. Now I do. Thank you. Okay. All right. Another scenario. Let's pretend maybe I'm a little older and my spouse just passed away, and really she handled all the money. I'm not too clear on what's going on here. I sure hope everything's in order, but it might not be. Can I call you?
Absolutely. Right,
What
so
you
these
gonna
are
do?
the kind of calls that we get frequently.
Okay.
Because people just don't know, right? I mean, hopefully only one time in your life does your spouse die, right?
Yeah. Right.
And generally speaking, your checking account is going to be joint, and so we see a lot that the surviving spouse just carries on because things are working, the bills are being paid, there's money there. At some point in time, though, it's time to update the surviving spouse's documents and make sure everything is cleaned up from the deceased spouse. So if there were any assets that were just in the deceased spouse name, it's time to probate those. It's time to get those transferred.
Okay. I got another question now. I don't know if you've been to my website, but I have, the greatest dog.
You do have the greatest dog.
You know Lou.
Second to Riley.
Well, we're talking about the relative merits of our dog, but that's
Fair.
another podcast.
Okay.
Purpose of this one, can you help Ann and I take care of Lou, our dog?
Yes,
after?
and Lou needs some good care if something would happen to you guys.
Right.
Georgia Codified Pet Trust, I think it was 2010. A pet trust, right? Pet is a personal property, right? So we don't usually think about trust for personal property. But you can have a pet trust. You can name a trustee and a guardian caretaker for your pet. You can allocate some funds for your pet's care. You can leave instructions for, what your dog likes to do, how often it should be groomed, et cetera, and then the trust will give directions for the remainder of any funds if your pet passes, leaving some assets behind. So I see a fair number of pet trusts in our documents now.
Yeah.
Folks are taking good care of their pets.
So after the dog, we can think about my children.
After the dog, we go to the kids, yes.
Yeah, so let's suppose that my wife and I die at the same time. Like, how are we going to designate who does what? Like,
Yep. How are you going to designate it? You're going to designate it in your will.
okay.
You're going to designate a guardian who would have physical custody and parental rights over your minor child.
Mm-hmm.
Okay? Guardianship lasts from infancy to the age of 18, and then it ends under Georgia law. Okay? You're also going to name a trustee. The trustee is the person who will collect the assets that you leave behind, your life insurance, the remainder of your 401k, what's in your bank account, and distribute those assets according to your wishes to your kids over time.
Mm-hmm.
Our general distribution standard is health of the child, education of the child, maintenance and support of the child, whatever it means to maintain and support your child in his or her accustomed manner of living.
Okay.
But you can be really specific with that if you'd like. I have a lot of parents who are really detailed with what their kid should receive over time, what schools they should go to, summer camps, travel. And then I have other clients who say, you know, my guardian, my trustee, they know us very well, they know the type of parents we are, they know what we expect from our kids, so I trust them.
Okay. Can guardian, trustee, can they be the same person? Should
They
they be?
can. Quite often they are.
Okay.
If they're not, I would like there to be a good, specific, articulated reason for that, and they need to get along well together. Because if you think about it, you've got a minor child living in the home of a guardian, you've got the trustee managing the money, they need to be able to coordinate pretty well.
Yeah. Okay. Got two more things I wanted to ask you about. I heard that the government is going to try to take all this money. As soon as I die, or the person I want you to write a will for dies, can you help me out with that?
We can help out with that. So we do have
Okay.
a significant number of clients, higher net worth clients is really how we're defining them. We are in a very taxpayer-friendly environment as far as estate taxes go. So estate taxes are death taxes.
Okay.
Those which are assessed at death by the IRS. Okay?
Mhm.
The state of Georgia does not have a death tax, so don't worry about Georgia. We're only worried about the IRS, and at this moment in time, we are only worried about the IRS taking a piece of your estate if your net worth is over $12 million
Okay.
per person.
Oh.
So for a married couple, your net worth has to exceed $24 million before you become a taxable client.
Okay.
Okay? It's portable between spouses, meaning it doesn't matter which spouse has the assets and who dies first. But here's the big asterisk, the big star. The estate tax exemption is what we call it, is something that our folks in Washington play political football with, right?
Okay.
It's right. Every election you hear it brought up.
Yeah.
The Republicans want a higher exemption, the Dems want a lower exemption, right? It just goes back and forth.
The exemption is that.
The exemption is that $12 million threshold. The way the tax code is currently written, as of 12/31/2025, the exemption will be cut in half. It's a sunset provision back to the 2010 law, indexed for inflation. Okay? The 2010 law was $5 billion. Indexed to inflation. So as of 1/1/2026, we'll be looking at a roughly $6.5 million exemption per person, so 13 or so for a married couple. So if you're looking at a net worth that exceeds that 12 million, you need to be doing planning in the next few years.
Oh, so you could plan earlier and then get locked in
Yes.
to the better rate. I don't have to die before the law changes.
No, please, no, we're not encouraging that at all.
It is for real.
Yes, it is a use it or lose it exemption. So right now you have the ability to use your estate tax exemption, it's called unified credit, before it goes away in 2026.
Okay.
So there's a significant number.
Or you can still live past 2026.
And you can still live past 2026 with the assets
Okay.
still not far away.
Okay. Last question, our topic. All right, what happens if I do none of this? I die without a will. Who's in charge then?
The state of Georgia. The state of Georgia has written a number of laws, a number of statutes as to where your assets will go if you don't have a will.
Do I have any control over that?
No, not unless you write a will.
And that's what she does.
We'll write your will. Write a will, get it organized, right? It's a gift to your family. If you want, it's peace of mind.
Thank you.
You're very welcome. Thank you for having me.
Thanks for coming.
Thanks for joining us on Asking for a Friend, the law you need to know. Find us online at www.butlerfirm.com.